they need to know that if you become a potential DCJ, Deputy Chief Justice, that you have the requisite skill set, backbone, and ability to directly take on corruption. Through the judiciary, we know there are many sites in which we're fighting corruption. But I'm very concerned that, again, as the leadership of the division, you're not taking accountability for where we are now.
Thank you, Commissioner. Commissioner, you must be mindful of the fact that those cases are not the only two corruption cases that were in the Free State. There were many, many, many other cases. And they were dealt with swiftly and justly and properly. There was no outcry about them. And the asbestos case, the prosecution wanted to forum shop, which is a fundamentally wrong thing for the prosecution to forum shop. Now, what you don't mention is they even said to the DJP, well, we want assessors appointed to assist the judge, and we want to choose the assessors. Now, how can you choose the presiding officers in your own matter? So, it's not a matter of not taking accountability. It is a question of when one looks at the entire picture, one sees that there was actually nothing about the asbestos matter, that the furor that they wanted to create, because ultimately the matter proceeded in the division.
JP, let me ask this more directly. Do you believe you exercised adequate oversight as the head of the division? And how do you account for that systemic failure that followed such a critical allocation decision?
When you say adequate oversight, I don't have oversight over cases. When you say allocation, yes, maybe, but you must also bear in mind that judges have other matters, firstly, and secondly, those matters are dealt with by different judges at different stages. But as a general proposition, yes.
Okay.
May I just follow up, CJ, with your permission?
No, there is another, people must not just jump in. There is another follow-up that already raised her hand. Then it will be you.
Thank you, CJ.
Minister?
Thank you very much, CJ. Judge JP Musi, just to confirm what you are saying, are you saying that when NPA requested the recusal of the Bloemfontein judges was on the basis that they were worried about the safety of the judges? Is that what you say?
That is
because
what
that's not what my understanding, and the letter I have seen, it's not even confidential that I would have seen in my capacity as a minister, but this is what has been in the public domain. The letters by NPA were circulated publicly. The response letters by then the acting JP was circulated publicly. And the issues that were raised there was mainly around the biasness and or perceived biasness that they were feeling that the cases were never going to be seen properly. Maybe if you can explain that. And then there's another part which also you spoke to as you responded to Commissioner Hassan, that I just want you to clarify. You are saying to the Commission that there are many other cases, so and therefore your understanding in terms of the relationship, what the NPA would have done there shouldn't have. Maybe if also you can explain how, as JP in the Free State, managing the relationship with the stakeholders that are critical as such as NPA.
Thank you, Minister. Firstly, the letter just mentioned the accused persons and said there's a premier involved and there are other highly placed officials involved in the case. But what they then honed on, and if you see, if you look at the letters, you'll see. Firstly, the point is made that the judges from the Free State are in a similar position and then judges from any other province when it comes to this issue, and that they have not mentioned any bias at all against any judge, and that is why the DCJ, the deputy JP, expressly said, well, if you feel that they would be biased, bring an application. And secondly, when it comes to the safety, judges in the Free State will similarly be imperiled like a judge from outside. That is basically what the letter said. And they have made no allegation about bias against a particular judge or a group of judges. No, they just mentioned that the accused, who the accused are, and they are a high-profile accused. So one can probably infer in that they meant all the judges will be biased.
Second part of that question,
Which was, Minister?
the issue of the relationship, because from what you are saying
no.
and what would have been articulated publicly by NPA as well does seem to suggest that there are issues of relation management. And that's why I'm asking, as JP, how is the relationship management with critical stakeholders such as NPA in ensuring there's effectiveness of our work in that province?
Minister, we were also baffled. As I say, I was at the SCA then. When the DJP told me, we were totally baffled that the DPP could do such a thing and send such a letter without even requesting the parties, because that is the point that we made. The DPP could have requested the parties on both sides to attend to the DJP's office and then discuss the issue before leaking the document to the press. And that was the issue. So the office of the Judge President and the office of the DPP in the Free State never had issues. Never ever had issues.
Okay, thank you. Maybe just to put in record, the letter does say that the results for request for recusal is on the basis that many judges had dealt with asset forfeiture application in respect of about 7 accused that were appearing before that court. Thank you, CJ.
Yeah. Yes, Minister, but that does not say they were biased. Because you can deal with an asset forfeiture matter and deal with a criminal matter. But I understand what you're saying.
Commissioner Lekganye?
CJ, thank you so much. Good morning, JP.
Is the follow-up?
Yeah, it's a follow-up.
Oh, okay.
Good morning, Commissioner.
Yes. Look, I listened to you when you responded to the question when the minister asked you for the first time. And correctly, when you explained, you said that the judge that you have appointed has been there since 1999. Is that correct?
Yes, correct.
Yeah, so mine will be that if you have made this decision to appoint this judge, like any coach who has options on players that must be fielded,
Mm-hmm.
and then the SCA comes and makes trenchant criticism on serious omissions of law against that judge, and then you appear before the Judicial Service Commission and questions are being fielded here before you for your response. As a person who holds office that must be seen as an office of unimpeachable integrity, do you find it difficult to say, in our line of work, there will be mistakes that happen, and this is how the mistakes can be corrected. Is that difficult? I mean, when you made a presentation here, you spoke about accountability, you spoke about everything that goes with your office. Do you find it difficult? South Africa is listening to you. Do you find it difficult to say against public expectations? The public did not expect the Supreme Court to go and reverse a judgment that was made at a provincial division. But it's not the findings of the public, it's the findings of a superior court. Serious omissions. And you are the person who has an opportunity to come before the Republic now. It's your opportunity, it's a penalty moment. What do you say?
Thank you, Commissioner. I've already said, as the JP, I allocated the matter to her, but she got it wrong. And the system is of such a nature that we all get it wrong. The fact that a judge is overturned at the SCA level is not the end of the world or does not signal the total incompetence of the judge. But the judge got it wrong, and many judges get it wrong. That is why we have courts of appeal. But lastly, let me say this. I agree totally with the Supreme Court of Appeal. I agree with it. In fact, if you look at the judgment of the Supreme Court of Appeal, you will see I disagreed on one point and one point only. I agree fully with the Supreme Court of Appeal.
Lastly, do you think in your response, was it proper for you to say other experienced judges have gone through similar experiences, their decisions were reversed by... Should that be the standard way of responding? Do you think such an iteration was proper for you to make it before the JSC to say other experienced judges have gone through similar experiences?
Thank you, Commissioner.
Or do you regret making such a statement?
Commissioner, the point that I made was that judges get it wrong. And that's exactly the point that you say. You field a player, but the player on the day is useless, does not score. And I'm saying, well, yes, I fielded this player. This player disappointed me. But the system is of such a nature that if a player does not perform, it's not the end of the world, because there are appeals and processes like that. And I even said I was upset on appeal, because it's not a badge of dishonor, really. Because even in our higher courts, well, the highest court in the land, the Constitutional Court, you'll find differences by judges. Sometimes they're even split right in the middle. The one sees it that way, the others sees it that way. So it was not to traduce the character of any particular judge or judges. No, definitely not.
But do you agree with me that we learn every day and
Yes.
then we correct?
Yes, 100%.
Thank you so much.
Yes.
Commissioner Mangen?
Thank you, CJ. What is this? Still a morning. Good morning, JP.
Good morning, Commissioner.
Look, allocation of matters is a management issue.
Yes.
So what is at issue here, as I understand it, it's the decision that you took to allocate a matter to the judge when it was of national importance, so to speak. Now, having listened to the questions that have been posed to you by the Minister, by Commissioner Hassan and Commissioner Al-Khanyan, and given the fact that hindsight is the best insight to foresight, were these situation to arise again, would you decide in the manner that you decided?
Thank you, Commissioner. I would probably not.
Thank you.
All right, commissioners, before I allow Commissioner Toby to follow up again, I don't think it really takes matters anywhere really to flog one question for 20 minutes or even longer. A candidate gives their answer. If they flunk, they have flunked. We make of it what we will. Otherwise, we'll be here until tomorrow. Carry on, Commissioner Ngubaitot.
Thank you, Chief Justice. I will stick to that. No, it was just a matter of concern that I had that you've accused the NPA of having leaked the communication and whether or not you want to revisit your statement on that, because I think an accusation coming from the judge president of such impropriety, because it can be a criminal offense for the NPA in certain instances to leak information related to an ongoing trial, whether you want to revisit that statement or not.
Yes, thank you, Mr. Nkaitobi. You will note in the communication that the Deputy Judge President wrote, that allegation is also made because when she received the letter from the NPA, the press already had the letter and the press already called her. And she spoke to the DPP to say, well, but how does this happen? I get the letter per hand, but the press already knows about it. And that is where that inference comes from. So there's no direct evidence. It's probably inferential reasoning, but they were told in no uncertain terms. And it was also part of the communication between the DJP and the DPP. So yeah, but maybe because it's inferential reasoning, and no, there's no concrete evidence. It's maybe an unfortunate statement to make.
Yes, but I mean, you stick with the accusation that they leaked that letter.
Well, they did not refute the allegation when it was made. So that's the point.
I've lost my list now. Commissioner Breitenbach?
Thank you, Chief Justice. Good morning, JP.
Good morning, Commissioner.
I'm afraid I'm not yet done with New Lane. I'd like you to explain, if you would, your view on the allocation of cases in your division. I would expect the most difficult and complex cases to be allocated to the most experienced and competent judges, and that the most complex cases be done by yourself as the head of that division. When you appointed this acting judge in the New Lane matter, did you appoint her specifically to deal with that matter?
No.
Or had you had the opportunity to observe and judge her work in previous acting stints?
Yes.
I'm not
But
done.
not
I'm not done yet, so just wait for the question, please. You're stating that the acting judge in question has 20 years of experience is really more concerning than comforting in these circumstances.
Yeah, thank you, Commissioner. The problem is you judge somebody by his or her previous work, the experience, the fact that the person is functioning in a criminal court for 20 years. So, and then everything goes pear-shaped, yes. You're 100% correct.
Yes, I'm interested in your allocation of cases in your division.
Oh, no. Firstly, as I have said previously, the fraud matters emanating from state capture matters are routinely done in the regional courts. This is a regional magistrate. So the idea was, well, it's a criminal matter. She has all the criminal experience. The matter may be allocated to her. But as a general rule, when it comes to opposed motions and matters like that, except for long criminal matters, I don't do long criminal matters due to the fact that I have other commitments and other work to do. Short criminal matters, yes, those I do myself. And furthermore, all pre-trial conferences in the division are done by me or the TJP.
Thank you. Then you say reasonably glibly that the acting judge got it wrong, and judges do get it wrong. Well, yes, I agree. Of course, no one's perfect, also not judges. But to get it so spectacularly wrong, to fail to apply the simplest elements of fraud to the facts, that's problematic, especially in the light of the excoriating nature of her judgment. So what will the consequences be in the wake of this judgment of the SCA? This acting judge is still on the bench. Will something be done to offer some form of training, something be done to improve the way she deals with, even despite 20 years of experience, improve the way she deals with matters?
Firstly, she's no longer on the bench. She was just an acting judge. She has been subjected to further training at the South African Judicial Education Institute. She is part of the Bridget Mabandla Aspirant Judges training, which is a training that spanned over a year.
Thank you.
Commissioner Godson?
Thank you, Chief Justice. Good morning, JP.
Good morning,
The
Commissioner.
Free State has long been associated with severe governance failures and the large-scale misuse of public funds. Now, in that context, there is a perception that the provincial judiciary has at times been overly deferential to the executive, particularly in politically sensitive matters. One example, which is often cited, is the court's refusal at the start of the asbestos matter to hear an urgent application to halt the first asbestos contract payment, which arguably enabled irreversible financial loss and, had it succeeded, might have prevented the now seemingly ill-fated criminal prosecution of the contract's beneficiaries. How do you respond to this perception? And as the Deputy Chief Justice, how would you promote a culture of judicial independence that resists undue deference to executive authority?
Thank you, Commissioner. Firstly, while it is a perception, I don't know where it comes from, but there might be a reason for the perception to be there. When it comes to the specific case, that case was case managed by me, and it was given to a senior judge. There were about 3 applications in that matter, and the NPA was successful in all 3 of them. Mr. Mahashule brought applications. They were unsuccessful. And currently, the matter is being dealt with by one of the senior judges there. I don't know where the perception comes from. And in many other cases, as I earlier said, there have been convictions. Yes, there have been a slew of problems in the Free State, and there have been convictions.
You say you don't know where the perception comes from, but in this specific application, it was brought as an urgent application, and it was removed from the role as not being urgent, and it subsequently led to massive financial losses.
Thank you, Commissioner. Well, that was in the civil court. Yes. And the judge exercised a discretion to remove the matter based on the fact that it's not urgent after hearing the parties. So, yeah, I don't know whether it would be proper for me to comment on the judge exercising her discretion.
Yeah,
and that was a senior judge in any event.
The second part of the question was, how would you, as the Deputy Chief Justice, promote a culture of judicial independence that resists undue deference to the executive authority?
No, clearly, all judges, all judicial officers ought to be impartial. They should not be subject to interference by any person, regardless of that person's standing and station in life. So obviously, when I become the DCJ, that will be one of my tasks to make sure that I foster a culture of judicial decisional independence. And it's something that I've always done, even in my time as a magistrate.
Thank you, Chief Justice.
Commissioner Matoloje.
Thank you, Chief Justice. Good morning, JP.
Good morning, Commissioner.
I mean, having had the discussions you had with all the commissioners regarding some of the matters that concern them, mine is just to find out, you say you have been, you are a spokesperson for the judiciary.
Yes.
South Africans are very unhappy with what is happening with our constitution. They don't believe in our constitution anymore. What do you think can be done, especially as a spokesperson, just to bring them back into the fold, to make them understand how it works and how it affects them? Thank you.
Thank you, Commissioner. I earlier spoke to the Minister about social media, for example. In many European countries, the judges of courts, as well as the administrative personnel of the courts, are allowed to block, to explain. Maybe what we should do, because the Supreme Court of Appeal, as well as the Constitutional Court, issue media summaries. We should probably look at a more innovative way to get those media summaries to the public. Maybe Twitter, Facebook, so that the public can read what happened in a matter and how a particular decision was taken, and what clauses in the Constitution were utilized in order to get to that decision.
Commissioner Lefanyane, your hand was once up. Are you covered?
No, I'm okay, CJ.
Thank you. Inkos Nkonyane.
Thank you. Morning, Chief Justice, and morning, colleagues. Morning, JB.
Morning, Commissioner.
Yeah, you mentioned that the right to equality is fundamental in South Africa, and I agree with that exposition. But is customary law, stroke indigenous law, equal to Roman Dutch law in South Africa? If it's equal, I would like your brief motivation for your response. If it's unequal, same, I will request you to tell us. Thank you.
Thank you, Commissioner. The problem with indigenous or customary law currently, and why it lags behind, is there is not yet a legislative foundation. Because, as you know, the Act is there, the Traditional Courts Act, and it emphasizes constitutional values, it emphasizes equality, but it is not yet operational. On the other hand, the Roman Dutch law, due to our colonial history, has been mainstreamed over the years. And for an example, in Elkscore versus the Rechterveld community, there the court said that the problem with our indigenous law is it is not always in writing. It is a law that is dynamic, but it is always relayed from generation to generation. So I think those led to that part of the law not being treated equally, because otherwise we would by now have had this law, the Traditional Courts Act, implemented. And you'll also note that the section on traditional leadership in the Constitution, probably the shortest chapter. There's no real elaboration on it. But when it comes to section 39, sub 2, I don't think any law can be said to be above another, because there it's clear, any legislation, the common law, or any other law, including indigenous law, should be brought in line with the object, spirit, and purpose of the Bill of Rights. So, yes, my view is, unfortunately, that the Traditional Courts Act is not yet there, but the law itself can be taken to the highest court in the land. And there's no way that it would be said that this law is supreme to this one. As long as it stands constitutional master in terms of 39.2, it's fine.
Thank you, JP. I hear you. But I also heard you, which is my second question, and the final one. You indicated that Apex Court correctly is the Constitutional Court, and the lowest is the Small Claims Court. My question then to you, according to did I understand you correctly, therefore, to mean that traditional courts do not exist in South Africa?
No, Chief. I think you misunderstood me, Commissioner. I expressly said the Apex Court is a constitutional court up to the traditional courts. Because in terms of the envisaged legislation, matters from the traditional courts can go to the magistrates court. It can even go to the small claims court, for that matter, if it's referred there. So there's no question about it. I've always been in this space. In fact, in 2020, I delivered a paper in Nairobi, Kenya, about indigenous law. And if my memory serves me right, you were also supposed to be there, but unfortunately you didn't make it. So I'm quite au fait with customary law and indigenous knowledge systems.
Thank you, CJ. I have no further questions.
Commissioner Mangena, do you still want to ask your question?
Yes, thank you, CJ. JP, I must commend you for highlighting the issue of the mental wellness of judges, because they work under difficult and stressful conditions. Their wellness deserves to be taken care of, and a job well done on that front.
Thank you.
Yeah. The question that I would want to ask you relates to your CV. I heard you respond to the CJ that you are an admitted attorney.
Yes, I am.
When were you admitted? Because when I looked at paragraph 6 of your CV, it tells me that you completed BURIS in 1985, and then you became a prosecutor in 1986, and then went through the ranks up until your appointment as a JP.
The Act gave recognition to magistrates and prosecutors who have been magistrates or prosecutors for a period of 5 years or more. And all that you had to do is attend the 6 months law school at night, and then you could go and write. It's exactly what I did.
Okay. Thank you, CJ.
Commissioner Balui?
Thank you, CJ. Good morning, JP.
Good morning, Commissioner.
Yes, JP, President Mulemela asked you for your priorities if you were to be appointed. What would be your priorities? You listed, at least I've got two. The one was digitization of all the courts, and the other, as I understood it, was that courts must be supported the same. And I think the example you gave was that you find some JPs have got an office manager, others do not have. So those are the two. What I did not hear is what difference does that make if you get that? What does it make to the customer of judicial services? Because on the face of it, it looks like nice to haves. It makes the lives of judicial officers easier. But for the listening public, I would imagine the interest is, what does it have to do with me? A related issue to that was the discussion about remuneration of judicial officers, that we need them to be better remunerated. Now, I accept that there is no debate or controversy that all three should happen. But what does it have to do with the delivery of services to the public? And I asked the question, sorry to be long, I asked the question because among the issues that we hear, it's the workload, shortage of judges, the long rolls, and we're a single judge in Tata in February, in unopposed motion, they have 143 matters allocated to them. The same situation in April. And that didn't feature in your list of priorities. And it's a matter of concern on the face of it, that you don't seem to be concerned about matters that have an impact on the quality of services received by the public.
Thank you, Commissioner. The digitization project, I don't think it is a self-serving one. It is actually one of the major forms that we can harness to achieve access to justice. Because if somebody there in the rural areas, deep Transkei, wants to serve papers in Bloemfontein, it becomes much easier if you do it digitally. Likewise, if you have evidence that you want to file via case lines. So to me, that's not a nice to have. It's actually an imperative. It's an indictment that there are courts that still don't have that. And when I referred to the capacitation of the officers, it is exactly so that if the office is better capacitated, you need more staff. When you have all these new things coming, you need more personnel to deal with it in order to make sure that things are filed properly. You will probably know in many courts that you have been, you will be told the file is lost. You can't get the file, or one clerk misplaced the file. So then when the things go to the JP's office, there is somebody there that can deal with it. So those are the two issues that I specifically honed on as part of the whole access to justice concept. Because, if we look at the rules, the client's attorney must have officers within a particular radius. That will be something of the past if we can file electronically. There might not even be a need for correspondence if we file that way. So that, in my view, is a major priority.
Thank you. A second question also arises from answers that you gave earlier, and this was, one of them was about funding, accepting funding. The judiciary have asked, rather accepting funding. Now, and I understood how you answered it, but I want to take to that as one of the issues, the use of acting judges, especially practitioners, legal practitioners. There's often a concern that you have the same practitioners who sit and act, they later come back to appear before the same judges. So what you alluded to earlier when you spoke about funding, whether we take money from people who are later going to appear before the court, it seems there should be the same sensitivity to using legal practitioners to act, because they are going to be appearing before people who last week were their colleagues on the bench. As a matter of policy, what are the issues that you think we should be alert to, the judiciary should be alert to, both in respect of accepting funding from sources other than parliament, but also utilizing especially legal practitioners as acting judges? And for me, this is a question about appearances of partiality or impartiality of the bench.
Yeah. Thank you, Commissioner. Look, unfortunately, the first one is very systemic. It has been happening over the years that practitioners act in a particular division, and the next week they are counsel again. That has unfortunately been the case. But I hear you, and I accept your point that maybe we should rethink all that. But the funding part, I do not think that we should receive funding even from individuals as such, because you just never know what might happen in future. And that is why I said we must be very circumspect when it comes to accepting money. If the donor is, for an example, from Europe, well, unfortunately, it can't be America anymore, from Europe and those places, and it's a reputable organization that works with judiciaries or with the judiciary, I don't think it would be a problem. The International Commission of Jurists would sometimes offer scholarships to judges or invite judges to conferences and say to the judge, if you don't have the funding, we are prepared to sponsor you. In that case, the judge must obviously disclose it, but secondly, the risk is minimal that that organization will appear in our courts. But the judiciary should make sure that there should not be that perception of bias. I agree with you totally.
Thank you, CJ. Thank you, JP.
Thank you.
Commissioner Trolley?
Thank you, CJ. Good morning,
Morning.
JP. I'm going to take the lead from the CJ and not flog a dead horse about the New Lane matter. But I do want to just make a comment, and that is that I did detect initially there was some dogged defense of the acting judge, despite the fact that the SCA ruled that there was a misapplication in law on 4 counts. That's a concern to me. But JP, in your response to a question from the Chief Justice about judges' remuneration, you said that ethics is an area of keen interest to you. It was your passion, and you mentioned Mervyn King's presentation around corporate governance and ethical leadership. And then you said that appropriate remuneration would prevent judicial officers being tempted to be on the take. Do you believe there are judicial officers that are on the take? And secondly, do you think that judges' remuneration is suitable to be able to attract the best possible legal minds into the judiciary from the private practice?
Thank you for that question. Maybe let me answer the second one first. That's one of our recurring pleas to the executive, to the commission, that we cannot attract suitably qualified and experienced counsel to come to the bench because the salary is just not attractive. They will tell you it would be an act of insolvency I mean, even when they come to act in the courts, they say, well, it's basically an act of insolvency. The first one, look, there are numerous cases at the level of the Magistrates Commission of judicial officers who have been charged with corruption and being on the take.
You have finished, Commissioner Trolley. Commissioner McClung?
Thank you, CJ, and good morning, JP Musi.
Good morning, Commissioner.
My question emanates from your presentation on the point you made about your involvement in efficiency enhancement committees, particularly at PEEC level, and also regarding the inefficiencies in lower courts. Now, with the right to a fair trial comes the right to have your matter be brought before a court of law and be expeditiously dealt with. And there are safeguards legislatively, such as your Section 342A in the Criminal Procedure Act, and also to a large extent, the efficiency enhancement committees are there to ensure that the right to a fair trial is realized. But the reality is that there are incessant systemic inefficiencies in lower courts, such as overcrowding of roles, late starting of matters, unwarranted postponements, and so on and so forth. What other measures do you think can be put in place to alleviate this challenge? Thank you.
Thank you, Commissioner. Because this is a system, it's a chain. One must look at where it actually begins. What is its provenance? Sometimes the police arrest too quickly. Because if the police arrest somebody, they take that person to court. Even in cases where they can issue a warning for the person to appear at some future date, they take the person to court on the next court date after holding the person for the duration that they are allowed to. But on the other hand, you have a situation where, as you would know from legal aid, you have one legal aid attorney in a court, and that legal aid attorney walks around with 10 files because he has 10 cases in that court, or she. And what then happens is, if one trial must run, the 9 must be postponed. That's unfortunately how it is. Now, it impedes access to justice. You also get a situation where the prosecution would not be ready to proceed with the matter, but the defense is not told beforehand. Everybody waits until the day of the trial. And it's only on the day of the trial that people run around and they want the matter postponed. So half a day, as I said, half a day of the court day is just gone. And then when they start the trial at 2 o'clock, they can't finish the trial. So I think what should actually be done is that the presiding officers should take more charge of their courts. Because if the presiding officer does not take charge of his or her court, anarchy reigns. That's the problem.
Thank you. Thank you, CJ.
Any more questions, colleagues? Commissioner Moimang?
Thank you, CJ. Good morning, Judge President.
Good morning, Commissioner.
Just two from my side. Uh, the first one relates to the non-appointment of permanent judges to meet the demand of the caseloads. In certain areas, this has been defined as the judiciary that is in a state of crisis. And this shortage of judges, to a larger degree, results in the delay in handling of cases. So the question that I want to pose to JP is, in view of the constraints and the constraints around resources, but more than that, the issues around the judicial posts that exist across the divisions. What will your proposal be in a view to ensure that a formula is formulated to sort of come up with a workable solution to address these vacancies, which obviously leads to crisis around access to justice. The first one, the second one relates to the point that you raised around the remuneration of judges. I know that between 2014 and 2019, JP was the chairperson, yes, of the Remuneration Commissions Committee. You took that from Judge Willie Seriti, and the current one is former JP Leo. It will be important just to get a sense from yourselves where the crisis is, because as the chair of that commission and committee, there will be concrete proposals that will make, which will attempt to address the areas that we raise around the non-adjustment of the salary of judges. Thank you.
Thank you, Commissioner. Look, the first point on the non-appointment of judges, every division has a establishment size. Like for instance, in the Northern Cape, it would be 7 judges. Now, if one judge retires, resigns, or just by way of attrition leaves, that position is vacant and the JP can fill it immediately because it's a funded position. Unless, of course, the JP has other plans with that position, with that vacancy. A formula, it's difficult to really work out a formula, because what happens is the judge president of that division looks at his or her needs and then fills a vacancy or not. But the major thing is, periodically, at least twice a year, the Judicial Service Commission Secretariat requests the judges, or judges president, to indicate the number of vacancies and whether the vacancy should be advertised. Now, it's then incumbent upon the JP to make sure that the vacancy is advertised. So the second issue relating to...
Maybe before you go to the
Okay.
second issue, there will be certain divisions which are similar in terms of population size, caseload, and economic activity. Will the approach that suggests that where there's a crisis, probably the sharing of those allocation, can it work, particularly in busy divisions, to address the crisis?
Yes, look, it will always be a crisis if a court functions predominantly on acting judges. But to work out a formula, I don't think so. I can't, for now, perceive of a way in which one can formulate a formula unless there is a proper study, work study, looking at the number of judges, the number of cases coming in, population size, and then say, for this division, it ought not to function with a percentage of 30% plus acting judges. But it needs professionals to go and investigate it. It will be very difficult for me, where I'm sitting now, just to make a judgment call, unfortunately. And on the second one, look, the commission always has competing interests. As the judges go there and make presentations to the commission, so too do members of the parliament and members of the of the provincial legislatures. Likewise, we have traditional leaders, we have local government councillors, but the purse is small. And we sometimes, as the commission, have made, I'm sure you know, recommendations that across the board, public office bearers should receive 6%. It goes to the presidency, and then a few months down the line, we get a government gazette that says nothing, 0% for everybody across the board. So, and then the constant refrain would be, but there is no money, there is just no money, unfortunately.
Thank you, JP. Thank you, CJ.
That was the last question of your interview, JP Musi.
Oh, thank you.
I just want to thank you for accepting the president's nomination for this position and for indulging us for half a day. Is there anything you wish to raise with us before we let you go?
No, CJ, I think I would be remiss if I don't thank the president for nominating me and deeming me worthy for such a high office. And I would want to extend my gratitude to him, as well as to yourself, the minister, all the commissioners here. Thank you.
Thank you, sir. You will
Thank
go. Colleagues, I propose that we take a short tea adjournment to stretch our legs and come back and deliberate before we continue with the rest of our business for the day. What time is it now? Come back at 1:15. Is that too long? Quarter past 12, it is.